Ayes. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before the court are admonished to draw nigh and give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Supreme Court. Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the first case on the morning docket.
Thank you, Your Honor. May it please the court. The first case on the docket for Wednesday, March 30th, 2022 is appeal number 121862, State of Kansas versus Orville William Sieg, Leavenworth County, briefs both sides.
Counsel, would you please come to the lectern and state your appearances?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Mr. Sieg, and I'm ready for argument.
Thank you.
May it please the court, Sean Boyd for the state of Kansas through Leavenworth County. I'm ready and present for argument.
Okay, thank you. Hodgkinson, when you're ready, you may begin your argument. I might warn counsel, that especially those that are experienced in the courtroom, we have new microphones. And compared to the old ones that were good directionally to pick up sound, these you pretty much have to be speaking into them. So if you'd adjust the mic to where you are speaking, that we would appreciate that, or at least those trying to watch on the live stream would appreciate that. So Mr. Hodgkinson, you may begin.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Orville Sieg. I request 3 minutes for rebuttal.
3 minutes is granted. Thank you.
Your Honor, this is a possession of methamphetamine conviction out of Leavenworth County, and several issues in this case. I was kind of planning on taking them a little bit out of order, although I know the court may direct me otherwise. But my first topic today was about the second issue in this case, which had to do with whether or not there was any 6455 evidence admitted in this case. And if so, whether a limiting instruction should have been given in this case. And in the absence of that limiting instruction, whether it was reversible error. The Court of Appeals in this case found that they weren't sure whether there was 6455 evidence or not. They seemed pretty skeptical of it, but said in any case, it didn't amount to clear error in this case. So I want to address sort of both of those points going forward, because I recognize I have to get both of them to get relief from Mr. Sieg. So the first question in this case is whether there was any 6455 evidence admitted in this case. And the court will remember that during the testimony here that an officer had discovered glasses case, an eyeglasses case under the passenger seat where Mr. Sieg was found in a vehicle, and which ultimately was discovered to have some methamphetamine in it. And when asked at trial, the officer said, I thought this was Mr. Sieg's because of word of mouth of his previous conduct and previous associations. And so the Court of Appeals, again, was questioning, is that even 6455 evidence? Is that evidence of prior bad acts by Mr. Sieg on a specified occasion? And cited this court's decisions in Molina and Richmond for its support of its skepticism in this case, I guess. And so I guess I just want to address those things and assert and urge this court to find and clarify that evidence of this type is prior bad act evidence as contemplated under that statute. The statute 60-455 is designed and intended by the legislature to preclude or regulate the use of propensity evidence. That this idea that, somebody did something on a prior occasion, that means they probably did it on this occasion.
But it's not on a prior, it's on the statute is specific about being on a specified occasion. And that's where the Court of Appeals disagreed with you, was you were the statement that was made was fairly broad, and they're saying it just was an event. So let's confront that.
Sure. And they cite this court's decision in Richmond, for that proposition. But I would, and, don't need to, but I would urge this court to, when you look at Richmond and what was really being decided in that case, Richmond was a case where the statement in that case from Richmond was that, they were some kind of questioning in a murder case about maybe a previous incident, because that client had a previous conviction for murder. And Mr. Richmond made statements to a police officer during an investigation about, do you sell crack cocaine? He said, no, I rob and kill people. But when you look at the district court's decision in Richmond, the district court said that isn't talking about some prior offense. It's talking about his identity today. And had it been talking about a prior offense, even though we didn't necessarily specify the date, that would have been prior bad act evidence. That if it was referring to something, even if we don't specifically refer to a date, it's still prior bad act evidence.
It seems like I'm not sure you need to argue the way you are. It's not that it has to be so specific that somebody's giving a date, but you have to have an event, a specified occasion, right?
There has to be something, there has to be an event. Yeah, it has to be conduct. But the testimony in this case was prior word and mouth about, it was about behavior, not just like reputation.
Well, is that true? To me, it seems more like character or reputation evidence than it does pointing to a specific bad act or prior act or other act.
Well, I guess.
What's the line? What's the, what distinguishes one from the other?
Sure, yeah. And this wasn't objected to on an evidentiary basis. So we don't have any sort of analysis of it from a, is it reputation evidence or something like that? I suppose it could be. I don't think they're mutually exclusive. It's not one or the other necessarily. It's not either or necessarily. So it could be that it's prior bad act evidence and reputation evidence. I'm not aware of any authority that says they're mutually exclusive.
But would we look to those reputation and character statutes for guidance? And they do distinguish the difference between broad generalities versus trying to prove acts by a prior example of the person exhibiting that characteristic. So is that a good analogy to draw? And we pull over that same distinction into this area?
Yeah, part of when I think about this and think about the analysis is what's the probative value of this if it's not referring to specific past conduct? That it's difficult to understand that. Now, I guess my answer to you, Your Honor, is I don't know. I haven't thought it through the lens of 47 or whatever the statute would be for that. I haven't thought through that lens and the cases. So I don't want to overstep my answer on that.
Well, if you, sorry, you want to finish your answer? I thought you were finished, but if you look at Officer Garver's testimony, what specific occasions does he reference in that testimony?
He says he's stating a conclusion that he believes that the drugs that were found in the eyeglasses case under the passenger seat in the vehicle were Mr. Sieg's, that he possessed the drugs based on word of mouth of prior behaviors. I think we can read into that. I don't think it's a leap to say what behaviors. I don't think he was delivering flowers or selling Girl Scout cookies. That it was prior behaviors that would lead to the conclusion is that Mr. Sieg had other involvement with possessing drugs or some other sort of bad acts. But that's the natural and really the only natural inference of that. If it's not that, I'm not sure what the probative value of it is at all.
Well, then how do you define specified occasion under 455 to make it fit such a broad characterization?
That it's talking about identifiable conduct, but not necessarily like on a particular day. Again, if not, it goes back to your question. This idea of, is it the case that, look, we all agree that you couldn't say, I arrested him for possession of drugs on September 9th under the statute, but I can say I arrested him for possession of drugs sometime in the past, and now we're not under the statute. If that's the case, I don't even understand why it was a statute. I mean, that's rendering the statute completely ineffective. That you can get around 6455 by just instructing your witness, don't be very specific, don't get into the details of it, and we're not going to be under the statute then anymore.
Based on our case law, wouldn't the appropriate remedy here to go across the street and change the word of the statute, the wording of the statute? Because here, I think the plain language of the statute says another specified occasion, and I, under your hypothetical, sure, under the plain language of the statute, that's what happens, and maybe that's a bad outcome. But is that something we can fix? I mean, the legislature chose these words.
Again, I think when you do statutory interpretation, you look at the statute and try to discern the intent of the legislature. I think is the understanding of statutory interpretation.
But how do you interpret, as Justice Wall said, specified occasion? I mean, what does that mean? Specified, it's pretty clear, what that word means.
I mean, again, I might analogize this to like thinking about somebody committing a crime. Do I have to show that a person committed a crime on a specific date? Generally, no, that's not an element of the crime. But I have to show that a crime occurred, that there was an event that occurred that meant whatever it is, the elements of the crime. Here, and for example, in this case, we have evidence that the officer is saying this person committed conduct in the past that I think can be reasonably inferred to be prior bad act evidence, and that's specified, that's evidence of a prior bad act on a specified occasion, even if I can't specify the date or, those
I'm
kind
not
of
talking
things.
about a date, but yeah, more what you were talking about. Let's use an egregious example even. He said, well, I think he raped this person because he's raped in the past. Okay, so that's what you're saying is that under the language of the statute, that could come in, right?
If the Court of Appeals interpretation of Richmond is right, then I don't understand why that wouldn't come in, because you did not
Right.
say there was a specific occasion of it. It's just this general sort of allegation of something without any specificity.
Right. And
And
that goes back to the legislature, if this is not what they meant, and we have cases, saying that, then why isn't your relief across the street?
well, I also think you have cases that, what do you think, and does the court think, the purpose of 60-455 is?
But we don't have to go to the purpose, do we? Since the plain language of the statute, we don't go into interpretation. It says specified occasion. That's pretty clear.
But if a interpretation of a statute would render it meaningless, I think you're also supposed to avoid that interpretation.
It's not meaningless when you talk about, he raped last year or.
If every time a person can get out of it just by not specifying a time or time frame or whatever, then I think it is meaningless.
Mr. Hodgkins, you're about out of time, and I'd like for you to address the first issue on sufficiency. And I just want to hear your argument that the paraphernalia involved, which was a spoon, wasn't proven to inject into the system. Go ahead and speak to that, if you would,
Sure.
before you sit down.
So in this case, there was a spoon found and some things, and so my client was charged with possession of paraphernalia.
And as I understand it, there was reference to syringes, but no syringes ever found
Were
anywhere.
found.
Okay.
And my client was charged with a spoon, which can be paraphernalia in the world. People can use spoons to ingest drugs. But the jury in this case was instructed that the spoon had to be paraphernalia by showing that it was used to inject drugs.
Is there any ability for the jury to infer that a spoon can be used to inject, because it's usually used in combination? Or was there any evidence to that effect?
Can I finish, Your Honor?
Yes.
So no, I don't think there's any evidence in this case that a spoon is used in some way to inject drugs in. I think we can look at this and say, oh, it was just, it was a clerical kind of mistake on the part of this, that they probably meant to say ingest, but the jury instruction clearly said use the spoon to inject this. And I don't think there's any evidence that you can infer even that the spoon is used to inject the drugs.
Are we getting blinded there by the typical way that we're used to thinking of injections for drugs and fluids of that type? But if you look at a common definition of inject, one of the definitions is to introduce. I mean, what the first definition is what we're thinking of is taking a syringe and injecting a drug. But if just looking at, this definition gives that as the first one. And the second one is introduce something into a passage cavity or solid material under pressure. Why isn't that what we
But
fit the definition?
so two responses to this. One, I mean, certainly we didn't even get into this at the Court of Appeals because the Court of Appeals said we shouldn't even be talking about this because it's not the question. They said the question isn't whether Mr. Sieg was using the spoon to inject. So that's not even part of the Court of Appeals decision. But try to answer your question. Yeah, there are a lot of ways that we can introduce that we can use paraphernalia for the consumption use of drugs, and there's a lot of different ways. But I mean, even under the hypothetical that you're talking about, there's no evidence and no experience that you ever use a drug for methamphetamine to put it into your body in any way. You may use it to prepare it, something for smoking it or whatever you're doing, however you're doing it. But there's no evidence that you ever use a spoon to introduce it into your body.
But isn't it causally related? I mean, that starts the process of the that it is part of the process that you use to then introduce it into your body.
Whether it can be, I mean, because there's no evidence of that in this case, that somehow it was, I mean, and to be honest with you, and surprisingly after all, I don't know. And there's no evidence in this case of like, can you ever use a spoon to get it ready to inject? I don't know the answer to that. Certainly there's no evidence of that in this case. And I don't think that's true, but there's certainly no evidence of that in this case.
I'll display my ignorance. How do you use the spoon?
Well, I mean, I don't want to get in, I really don't want to get into things that I don't know. I've envisioned it and seen cases where it's used to heat up different kinds of drugs in order to prepare them for smoking or different kinds
Or
of
injection.
inhalation. Well, I'm not aware, again, there's no evidence of that. I'm not aware of that.
Does there have to be evidence for that?
There has to be evidence to support convictions that this was being used with intent to inject this.
Okay, so I'll ask the more concrete question. What was the evidence with regard to the spoon from your perspective?
That it may have been related to drug use, but not for the purpose of injecting any drugs.
I guess I'm
Yeah,
just curious,
and-
what's the other purpose?
Yeah, and I'd have
Like,
to, I
what
mean,
other purpose is there?
and I'd have to look at, I mean, I don't even remember, a more accurate answer to your question, Your Honor. I mean, I don't remember if they went into great detail about the use of it and the record in this case. But that's certainly, to the extent that it's not there, it's not our job to put on the evidence of how you use a spoon.
That
in a
question may be
particular
better directed to the state.
For my colleague, yeah.
I have a quick follow-up to Justice Standridge's questions. If we concluded that the hypothetical, there was a rape last year, is specified enough to qualify under the statute, how does that help your client when the language we're talking about here isn't a crime, rape? It's, at least my reading of the record, behaviors and associations.
It's particularly with regard to the behaviors, and it's connected to the answer to
Behaviors don't
Justice
have-
Wall's question.
I'm sorry.
That in the context, when the officer is saying why, he's saying, I thought these drugs were possessed by Mr. Sieg. And the reason for that is because of his prior behaviors.
And aren't there behaviors that are non-criminal, which could still be relevant to the question of possession? In other words, I don't see that the word behaviors necessarily suggests a prior crime or civil wrong.
I'm not aware of anything like that, Your Honor. I mean, the inference is that
Well,
the
how about
reasonable
just
inference
hanging
is,
out with known
drug dealers, let's
Well,
say.
that's, I mean, that might be the association side of it.
It's also behaviors, isn't it?
Well, he said behaviors and association and associations. So, I mean, it's our argument that the idea of behaviors is different than association.
But your argument would require us to interpret the word behaviors as meaning crimes. It has to be
in
a
the
crime,
context, in the
right?
context of the answer, yes. That otherwise, I don't understand the probative value of it at all.
Don't mind, I want to move you back to issue 1 again. And so one issue you had under this sufficiency was the spoon. The other was the junction and with the pipe and the spoon. And so this is my kind of me asking the analytical process to go through on this whole sufficiency thing. Only the legislature can specify the elements of a crime, right?
Yes.
And it seems to me your conjunction argument, the pipe and spoon or whichever order, is trying to say that, to me, is saying that the court's adding its own element to the crime. In other words, in order to find this possession of drug paraphernalia, you have to find that both the pipe and the spoon were used for these purposes, where I think you could be convicted of that crime for possession of one or the other. So it's your, I hate to use the word inject, but it's your use of the word and. It seems to me you're saying the court can change the elements of the crime. So how am I wrong about that?
So only the legislature can write a crime, but under due process, the state can charge something that's more specific than that crime. And under due process, then the state has to prove the crime that they charge. I think that's a fair statement. And so to the extent that the state in some way narrows or limits or whatever, its allegations in its complaint, its charging document, then I think the state has to prove what it charges. It's not changing the elements, it's not redefining the crime, it's looking at what did the state charge. And then, importantly for our second part of our argument, when the judge instructs the jury, again, that's not changing the elements of the crime, but when we're reviewing a conviction, we have to say, what did the jury actually find? And lay the evidence up against that. And how can a jury find anything but except what they're instructed on?
But I'm looking at the charging document and I don't see the word and in there. The word and that you've been focusing on in your brief, as I understood the argument, came from the instruction. And that seems to me to be an argument that says court's instruction can change the elements of a crime.
It's not that it changes the elements of the crime, it's that it tells us what was the jury told they had to find in order to convict this person.
That's the same thing as redefining the crime. The instruction can't redefine the crime, right?
The instruction tells the jury, here are the elements that you have to find in order to convict this person.
Right, but if the instruction adds an element that's not in the statute, what do we do with that extra element? To me, if you're saying you have to, that in order to be convicted, you'd have to do both because of what the instruction said, that's redefining the statute, the way I'm looking at it.
Well, I disagree. I don't think it is. I mean, I think, again, that these are different things. There's the definition of the statute, the definition of a crime by the legislature, the charge, which, has to at least, have those crimes, but is not necessarily have to be identical to that. But when the state does charge something, some part of it, then they're restricted to proving that. And that the instruction then is telling the jury, here's what you have to find in order to convict this person. And then if we can assume then that that's what the jury, the representation that this is what the jury found in order to convict this person. And then an appellate court would be reviewing that.
Questions?
Thank you, Your Honor.
May it please the court, state of Kansas through Sean Boyd for Leavenworth County. I would like to go through it essentially the same way the defense counsel, our appellate counsel just did, starting with issue 2 and then moving to issue 1. But if the court wants to change that or has anything more direct, I'm happy to answer any questions the court has. Looking at issue 2, whether or not the limiting instruction should have been for possible 6455 evidence, I don't believe it would be factually or legally appropriate here in this case. What 6455 specifically lays out, it's much more specific than whatever came in this case. It's for evidence of prior crimes, specific crimes or wrongdoing on a specified occasion. And that is not what we have here. The exact quote that Officer Garver gave, more than just the behaviors and associations, was when defense counsel had asked him what makes him think the drugs and paraphernalia are Orville Sieg's. He said, based on my observations of what the defendant was doing when I pulled him over, along with the area they were in, prior word of mouth of his behaviors and associations, I believe the narcotics belonged to Mr. Sieg. Now, that is also after Officer Garver had been on direct. He'd already given quite a few examples of why he believed that the glass case, the paraphernalia, and the drugs were Orville Sieg's. But what we look at here is there's nothing in that statement that actually goes towards 6455. There's nothing specific either regarding crimes themselves or an occasion. Now, when we look at that, when we talk about prior word of mouth of behaviors, behaviors really can be anything, as I believe was kind of pointed out earlier and what I pointed out in my brief initially. There's nothing there specific to talk about crimes. It could be anything that the officer has seen, if he's known him for years, anything like that. But he's not getting anything specific to kind of avoid the problem of bringing up, well, this is a bad person, you should find him guilty because he's a bad person and he's done bad things. That's not what happened here. When we talk about the associations aspect of it, that actually could be quite a few things too. And that could actually be stuff that was testified to in evidence here. Because if the court recalls in the facts of the case, Officer Garver testified that when he first sees the vehicle, it's in front of a known drug house with a man named William Cheatham, who they know to deal drugs. He is on the passenger side where the defendant is later found. And that could be the association he's talking about, just that, hey, I see him with somebody who I know has those problems. But it also could be just, I see him around town, I kind of know where he goes and what he does, but it's nothing specific. Defense in his, or the appellant in his petition gives kind of a example of why this could cause problems. And he says that it's ambiguous, and it's ambiguous kind of for a reason, to avoid 6455. But in his example in the petition, he says the state could really just have their witnesses say really anything kind of ambiguous to avoid 6455. And the example he uses is this person committed a drug crime or crimes in the fall. Well, that may actually be 6455. It's much more specific than anything that was testified to here. When in his own example, he says drug crime, well, he's then talking about a defendant who's committed drug crimes in a drug case. That's something that could be like, hey, look, he's done these crimes in the past, therefore he's probably done this, which is exactly what 6455 is for, to show, look at these bad acts that he did in the past, that's why he did this. And he even gives in that example a specific time in the fall. So recently this man did these bad acts, so therefore you should consider that when you're doing that here. That's not what we have. So I don't believe legally or factually that that instruction would be appropriate here. And in fact, even if that instruction was there, it would emphasize more and be probably worse for the defendant if that instruction, limiting instruction, was there. Because essentially with a kind of a vague statement there, it could be a lot of things. It could be really anything. And it's not specified to anyone. But if that limiting instruction is given, then you are clearly pointing out, well, that vague thing that we just talked about, that is a bad act. That is a bad act this person just did. And so even if the court finds that that instruction would have been legally or factually appropriate, I think that was still given a better chance for the state to get the conviction that we did. And looking at the evidence itself, when we look, if the court does believe that this would be legally or factually appropriate, then would the court be convinced that the jury would have reached a different verdict? And I don't think that's the case here, because if that instruction was given, it would give more emphasis that Orville Sieg's done bad things, that he's that those could have been crimes instead of something kind of not specific. And the evidence though itself was still pretty overwhelming for Sieg. So I don't believe a verdict would have been any different. But what the defense is asking you to do would be a very large extension of what 6455 is. It would essentially say that anything that could possibly be taken up as maybe bad acts or prior bad acts should get that limiting instruction. And there's a lot of reasons defense attorneys don't do that. Again, not to draw more emphasis to it would be just an example, but it would be a very large extension of what the legislature has set up to be 6455. So given all that, I don't believe that the instruction itself would have been factually or legally appropriate. And even if the court does find that it would have been, I don't think. If anybody has questions on that issue, I'll be glad to answer those. If not, I'll move on. When we look at issue 1, the insufficiency or evidence for the paraphernalia. Now, the defense argues that the instructions are essentially incorrect, that the state needs to prove what it was charged and then what was in the instructions. Well, in the instructions, what we end up having is the elements of the crime are correct. They are what was charged initially. The charge for the possession of paraphernalia was charged that the pipe and the spoon were used to ingest, inhale, inject, or otherwise introduce a controlled substance into the body. And that's the evidence that came into court. The evidence from Officer Garver was that based on his training experience, that the pipe and the spoon are both paraphernalia, drug paraphernalia that he knows is used to ingest narcotics into the system.
And the specific word he used in his testimony was ingest. I don't want to characterize as being picky or not picky, but inject is what was in the instruction.
Well, but the inject was in the instruction for the definition section. The actual elements of the crime itself and the instruction there still said to introduce. And that is really the evidence that came in, that it was to ingest.
So what do we do with that kind of inconsistency or contradiction or lack of inclusion of the right word? Is there anything we do? Because you're right, it's the injecting is in the definition part of the instruction, but the instruction itself that instructs on the crime, it's not there. So what do we do with that?
Well, in looking at that, if we look at the instructions as a whole, and I made this argument in my brief as well, if we look at all of that as a whole, I think the jury still can find that the defendant was guilty of the possession of paraphernalia. What we look at with that paraphernalia itself was that it was we have a pipe that had the defendant's DNA on it. The spoon itself had, it was packaged in the eyeglass case with the pipe that had the DNA that also had residue. The spoon itself also had residue. It was also all found in the same case with the methamphetamines. So when we look through the instructions, the elements themselves were correct. The definition was wrong, essentially a clerical error. But even as we go through the instructions themselves, there's an instruction that talks about that the jury can they can use their common sense, their life experiences essentially to examine the evidence. And if they do that and all the instructions as a whole, I still think that we're fine there, that the instruction for the possession of paraphernalia goes to introduce. While there may be a clerical error, I don't think that makes it completely false. Now, would that be legally or factually appropriate? Possibly. I do think that it was a clerical error essentially on that second one that was never objected to by the defense.
Let's follow up on this clerical error because, and again, I'm trying not to be too picky, but at the same time, statutory interpretation tells us that when the legislature uses different words, they're supposed to mean different things. Otherwise, they'd be unnecessary. You've got a statute here that says, possession with intent to use any drug paraphernalia to inject, and then it says, comma, ingest, inhale, or otherwise introduce. And I realize they're trying to throw a pretty big net over everything. They're separate terms in the statute. And then when we get to the instruction, even if it's a clerical error, picked one of the terms and not the other. And your evidence is using the other term not the one that's in the definition. And that gets back, I think, to, well, the argument of the defendant and Justice Rosen's question is, how do we just ignore that?
Well, the interesting thing about the possession of paraphernalia statute, when we start talking about ingest, inject, inhale, or introduce, all of those are things to introduce like drugs into the system. If you inhale something, you're taking drugs into the system, you're introducing into the system. I think it's kind of a broad, and it's hard for me to get into statutory interpretation or their legislative intent when they chose those words. But all of those are words that essentially mean to introduce. And that's the word that we use during the instruction. So when the officer says that they're there to ingest, and that ingest can be putting it through the mouth, introducing that into the system. Injecting, as was brought up earlier, can be the same thing, that you're taking those items that you're inhale, ingest, all of those are essentially kind of, it's just different processes to do it. Could just be, and again, it's speculation on my part, and I hate to do that. It could just be the way that they kind of put a broad brush to show, are you using drugs with this item? So, but past that, I couldn't tell you what the legislative intent was.
Trying to apply the statutory interpretation rules. Let me circle you back to the question that I asked toward the end of defense counsel. You would agree that it's the legislature that has to define the elements of the terms, that a court has no ability to add terms, add elements to a crime.
I would agree with that, yes, Judge.
And you'd also agree that you're bound by your charging document.
I would agree with that, yes.
So the discussion here with this first issue is, what role do the instructions play? And it becomes really complicated, it seems to me, because we have instances with alternative means crimes, and we have options within means, and states have to elect, and usually those elections are, made in instructions, or I suppose in the closing argument, if you're really getting dicey about it. So the discussion here is, what role do the instructions play?
And I won't disagree. Sometimes it can be confusing for some of those. I think the instructions themselves play a role to guide the jury in deciding whether or not that person is guilty. And we've met out that each one of these elements that make up the crime are found to make him guilty or not guilty. And in this case, I think that is essentially what happened when we laid out those elements. Now, the charging document itself and the elements that were in the jury instructions were very similar. The elements in the jury instruction did take out inhale, ingest, or and just left it as introduce. But that was also in the original charging document. So when we look through this case, the state did present evidence that would have fit the charging document itself, but we also presented evidence that these drugs or this paraphernalia would have been used to introduce drugs. So I do believe that we have to follow what is on the charging document, sometimes make decisions, clarify that into the jury instructions, but we did that and we clarified it down to introduce. And I think, so either way, I think here, even if the court does find that this was an error, clear error, I don't think it would have changed anything here for the jury, and the verdict wouldn't have been any different.
That'd be if we were here on an instructional error, but this is framed as a sufficiency question. Sufficiency question even apply. Instruction does something that adds an element. Jury needs to find that the statute and the charging document wouldn't require. See the distinction I'm making?
I do, and I think I'd hate to speculate on that because it was never briefed, it was never brought up before. The defense did kind of do the position that we have to talk about the possession of the spoon and the possession of the paraphernalia, or I'm sorry, the possession of the spoon and the possession of the pipe are both paraphernalia. But I'm not sure, and I'd hate to tell you wrong.
Is the jury permitted to use their common knowledge
They
about
are.
spoons and pipes?
They are.
Or does the state have to put on concrete specific evidence about the manner in which the paraphernalia was used to introduce the drug?
And I'm sorry, I didn't mean to cut you off. They are. They're even given that instruction that they're used their common sense. And that's one of the things that I even argued in my brief, that spoons are very commonplace. It's something that we see it in TV and movies all the time, and how spoons are used. Now,
And am I correct, using my common knowledge, as limited as it is, that a spoon could be used to both ingest or inject a drug into a person's system.
It can be even for methamphetamines, because methamphetamines actually can be taken and chewed and eaten. You can
You
also.
could use it like you use it when you eat your yogurt.
Right.
Or you could use it as one step along the process of putting it into injectable liquid form.
Right. So I believe so. I see that I am out of time. If there are any more questions, I am happy to answer those. Otherwise, I'll rest on my brief. Thank you. I appreciate it.
Hutchinson?
Just a couple of points, and I guess on one of the last points I want to get to. I mean, jurors can use sort of common knowledge about common things, but I hope that that the rule isn't that we can have convictions affirmed based on what I know from TV or TV shows, because that's not a very, I don't think that's necessarily very accurate. I mainly wanted to respond to my colleague's note that I didn't get to very well on my argument about the second issue. The Court of Appeals said they weren't sure whether it was prior bad act evidence, but even if it was, and a limiting instruction should have been given. It wasn't clear error, and my colleagues suggest here that the evidence was so strong against Mr. Sieg that it wouldn't have, even if we're right, it wouldn't have made any difference. I first of all would dispute, I mean, the evidence was entirely circumstantial with regard to possession of these drugs. And I know circumstantial evidence can support a conviction, but it's also not direct evidence. The evidence was entirely circumstantial. And by the way, how's the best way that I know that if there's a real possibility that there could have been one or more jurors that came to a different conclusion? Because they did in the first trial. In the first case, there was a hung jury, and based on the presentation of evidence, one or more jurors had a reasonable doubt based on the evidence. So I think there is a real possibility that if this court finds that a limiting instruction was appropriate, that could have made a difference, because that's the type of case this is. Thank you, Your Honor.
Thank
See
you.
you in Great Bend.
Thank you to both counsel for your arguments today. The court will now take this matter under advisement. The court is now going to be in recess. We will reconvene at 10 a.m.
The Honorable Justice of the Supreme Court, discourse from recess, now sitting.
Please be seated. Mr. Shima, would you please call the second case on the morning docket?
The second case on the docket for Wednesday, March 30th, 2022 is appeal number 122252, State of Kansas versus Carity M. Buchhorn, Douglas County, briefs both sides.
Counsel, would you please approach the lectern and enter your appearances?
May it please the court, the state appears by Deputy Solicitor General Chris Elsliger.
Good morning, Your Honors. May it please the court. My name is Bill Skepnick, and together with my co-counsel Quentin Templeton and Stephen Skepnick, we represent Mrs. Buchhorn, who is also here with her family. That's the crowd.
All right, thank you. Elsliger, whenever you are settled and ready, you may begin your argument.
It please the court. I am Chris Elsliger of the Attorney General's office, appearing on behalf of the state. And just by way of explanation, after a review was granted in this case, Douglas County Attorney's Office asked our office to take over the case for various reasons. So that's why I'm here, and to use my well-used baseball analogy, I again feel like a bit like a relief pitcher coming into the ninth inning. Seems to be the last 4 or 5 times I've been in front of this court, it's been that way. But you'd think I'd start getting good at it. So my first order of business would be, I would like to ask for 4 minutes of rebuttal time.
Floor is granted.
And this case involves a defendant who was convicted of second-degree reckless murder in the death of an infant, OO, who was in her care at the time. She worked in a home daycare center where the baby had been dropped off. Longtime coroner, Dr. Eric Mitchell, concluded that the baby died, suffered an almost instant death after suffering a head injury. The defense hired an expert of their own, another forensic pathologist, to counter Dr. Mitchell. This was Dr. Wigren, who believed or concluded that the injury was much older, and so the infant could not have died instantly after suffering this injury, and that therefore the death could not have happened while the infant was in the care of the defendant. The defendant was convicted. Post-trial, she hired new attorneys who then filed a motion for new trial and challenged the effectiveness of her prior counsel, arguing that prior counsel had failed to properly investigate Dr. Mitchell's theory on the cause of death and had failed to properly present expert testimony to counter it. The district court rejected that argument, found that counsel was effective, but on appeal, the Court of Appeals held that counsel was ineffective in their presentation of the case. So that brings us here. The state filed a petition for review, and opposing counsel filed a cross petition. Both were granted. I think at the beginning, although I know the court is well aware of the standard, but it bears repeating to kind of get us all grounded again on what the standard for ineffective assistance is. It comes from Strickland v. Washington, U.S. Supreme Court case. And the standard for performance is objective reasonableness. Objective reasonableness. And it's not about what another attorney would have done. It's not about what the best attorneys would have done. It's not an exercise in grading counsel's work. Counsel's performance is not expected to be flawless, as many courts have said. In fact, the U.S. Supreme Court has said that. The other thing that Strickland tells us, we have to avoid the distorting effects of hindsight. In hindsight, you can always look back on something and see how something different could have been done, something better could have been done, maybe another stone could have been overturned, but that's in hindsight. Have to view it from the perspective of counsel's point of view at the time in the context that they were dealing. And significantly, it's not about what counsel could have done. The review is based on what counsel did do, what they actually did, and whether those actions were objectively reasonable when viewed from their perspective at the time. So I think the Court of Appeals erred in 3 fundamental ways here. First, they focused almost exclusively on what counsel could have done, what more they could have done, how they could have done it better, as opposed to assessing what they actually did and whether what they did was reasonable. I think the Court of Appeals fully gave into hindsight. They looked back and said, well, it could have been, with the benefit of hindsight, this could have been done better, but that's not the standard. And then finally, the Court of Appeals also did something the appellate courts are not supposed to do. They clearly reweighed the evidence and significantly resolved conflicting evidence in a way that supported their opinion rather than deferring to the district court's findings. So,
Counsel, let me maybe add to your list. But even if you get past error and you get into whether the failure was harmful, at page 13 of the Court of Appeals decision says, quote, a finding of guilt becomes highly questionable, period, close quote. That's not the test, is it?
no, the test is whether there is a reasonable probability that the outcome would have been different. And to jump ahead here, I mean, I'm going to skip over a whole portion of my argument. I'll come back to it. But to jump ahead here, and let's say that, Dr. Mitchell was prevented from using the word depolarization or whatever it was, or you had these other experts that they brought in at the post-trial hearing and they testified. Regardless of that, the crux of this case was Mitchell said death occurred immediately. It was, this blow to the head happened, death occurred immediately. Dr. Wigren said, no, it was an older healing wound and it could not have occurred immediately. So it couldn't have been this defendant. That was the crux of the case.
There's nothing to support that the death can happen immediately under Dr. Mitchell's theory, is there? There's no statistical information. There's no learned treatises that supports his theory of depolarization. At least I don't see it anywhere, and he seems to even admit that.
The actual mechanism, I don't know, but the thing is, we all know that people can die from a sudden blow to the head. I mean, you don't need to be a pathologist to know that. So that's his opinion, and that's what he is.
Isn't that accompanied by some injury, some visible injury, or at least some brain damage?
And that was the argument between the experts. That was the point that Dr. Wigren pulled out. That was counsel's strategy, and that's what they brought out. I mean, you're right on point. Yes, that's exactly what they did. Counsel got another forensic pathologist to come out and counter that and say, there's no way this could have happened. There would be signs of injury, there'd be brain swelling and so on. But the jury didn't believe it. So back to Justice Biles' point, no, there's no prejudice because the jury heard all that and they still rejected the argument of the defense and they went with the state's case. So there's no probability that even if you'd had this additional evidence, or if the term depolarization had been taken out, that the outcome would have been different, because the crux of the case was Mitchell said it happened immediately. Wigren said, no, it was an old healing injury. There would have been, if it would happen immediately, there couldn't have happened immediately.
There's no scientific support or any support for the theory, for the testimony that Dr. Mitchell provided for the cause of death. There's just none out there. So,
Mitchell provided his own experience. He cited to cases where he had worked regardless, he had some basis for it. As an expert, that's his prerogative. He provided this basis for us. Now, the other expert countered that. And the crux is that, the defense did what they were supposed to do. They found another expert. They found another forensic pathologist who said, no, Dr. Mitchell is wrong. And that's what the case came down to. So I don't know how you can fault counsel for not investigating, for not hiring experts, because they did exactly that. I think when the district court said it best. I want to go back to the district court's conclusion or ruling on the ineffective assistance claim. The district court said, Mr. Morrison and Ms. Dersch searched for an expert, consulted with the expert, and hired the expert who directly contradicted the state's theory of the case. Now, that expert, Dr. Wigren, had access to the autopsy video, Dr. Mitchell's report, and the slides. His only disagreement with Dr. Mitchell was the timing of the injuries. That was the crux of the case. Now, in addition to looking at all the information, Dr. Mitchell had all the information that Dr. Mitchell had, Dr. Wigren also consulted a pediatric pulmonary pathologist and a pediatric neurologist. So they consulted other experts. But the court went on, attorneys are not medical experts. Okay, Mr. Morrison and Ms. Dersch hired a highly recommended forensic pathologist who believed the victim's injuries predated the time he was in the defendant's care at daycare. They relied upon their expert and his knowledge. Now, if the jury had relied upon the testimony of Dr. Wigren, the verdict would have been not guilty. So counsel did what they were supposed to do. I mean, let's you unpack that. I mean, clearly they did enough investigation.
I mean, we've read the record. I have a couple questions about what you've said that are legal issues. Number one, you said the Court of Appeals erred that in the ineffective assistance of counsel analysis, you only look at what the attorney did do. You can't look at what they didn't do. And what case did you cite in support of that? Seems like if, you know, if they didn't hire an expert at all, you're saying that that couldn't have been
Well,
ineffective assistance of
No,
counsel?
that is an act. I mean, that is what they did do as an omission. But the site for that, I mean, the cases on this are legion. I have.
No, but
books
the
in my-
point I'm making is that you would agree that an omission also counts as, I mean, you're.
Yeah, I mean, but first, let me give you the case where, I mean, I've got one noted in my notes here. It's Williams v. Wooford, 384 F 3rd 567 out of the Ninth Circuit, 2004. It's a
587,
I'm sorry, 384 F 3rd 567,
567.
page
Okay.
616.
And then my next question is, when you're talking about how important the legal framework is under Strickland, in the prejudice prong, you not only, I mean, in showing that the outcome would have been different, but the reasonable probability, our court has defined it, is one that is sufficient to undermine the confidence in the trial's outcome. Would you agree with that?
Yeah, that's what the court has said. Yes, that is
Okay.
that is a standard. So I think, again, when you look at, you have to, when you look at what counsel did, the point is you don't use hindsight and go, well, and grade their work and say, well, they could have done more. A better attorney would have done this, whatever, because you bring it down to the bar of what would an objectively reasonable attorney do? If what they did was objectively reasonable, then that's good enough. So if not getting an expert under the facts and that were known to counsel at the time, if that was objectively reasonable, then that's okay. And in this case, of course, they did get an expert. I mean,
But
Yeah,
go ahead.
please, Chief Justice.
Well, I was just going to say, didn't Professor Craig, though, take the position that they had deviated from the standard of care by not getting forensics, radiologists, biomedical engineers, other experts? But more importantly, I think perhaps by not filing a Daubert motion. And so it's not so much just that they would have disagreed, but it seems at least that her testimony is phrased in terms of falling below the standard, deviating from the standard. Am I correct in that interpretation? And if I am, how would you respond?
I have a lot of response to that. Number one, that is getting into the whole thing the Supreme Court said we're not supposed to do, which is getting into it's not about what another attorney would have done or what the best attorney would have done. And I think
that's different than saying,
well, I think that's
what the best attorney would have done or what I would have done, but saying what a competent standard of care would be in this situation for attorney.
well, and I think Ms. Craig is wrong. She is basically testifying from the point of view of hindsight after knowing how it all panned out, saying, well, this more could have been done. And basically suggesting this is what another or an additional attorney would do. And I think it's also a bit odd in a case, well, I think in all cases of ineffective assistance of counsel to have a defense expert, because expert testimony is appropriate to help the trier of fact understand a technical area, a technical subject that is beyond the trier of fact's knowledge. But last time I checked, every district judge is a lawyer, went to law school, passed the bar, practiced law. So the standard of performance of a lawyer is not beyond the trial judge's knowledge. And then you have two other lawyers in the room also telling the judge what the standard should be. And then when the defense takes another defense attorney and puts them on the stand and suddenly just makes arguments of counsel into evidence because it's coming from the witness stand, I think that's inappropriate. It's also inappropriate in this case when you want to say,
Objected to?
well, this is me making the argument to the court. I don't think it's appropriate. But Alice Craig compared to Paul Morrison, who's the real expert here? I mean, Alice Craig, she's no slouch. I mean, she's been around for about 20, 25 years, but her experience pales in comparison to Paul Morrison, who practiced for nearly 40 years. He was the district attorney, one of the largest jurisdictions in this state. He's tried more homicide cases than I have fingers and toes. He was a district attorney, the attorney general, and over a decade as a criminal defense attorney. Who's more the expert here? I would submit Paul Morrison is the expert in his opinion, and what he testified to outweighs anything that Ms. Craig would testify to. And the district court rejected Craig's arguments or her testimony by pointing out specifically that she relied on hindsight. And she relied on the assumption that a Daubert motion would have been granted, but the court said after hearing all the evidence in the post-trial motion, the court said I would not have granted a Daubert
Counsel,
motion.
can you refresh my recollection of what Mr. Morrison testified to as the rationale for the choices he made not to challenge Dr. Mitchell's testimony?
Well, one, of course, he relied on his experts, his forensic pathologist to tell him, what the problems were with Dr. Mitchell's testimony. And I've got legions of case law that say, attorneys it's okay. It's effective performance to rely on your expert. That's why you hire experts. He also basically said, I didn't think that such a thing would have worked because, Dr. Mitchell has been a very long experienced coroner. This court has quoted him and mentioned him many times in many cases in Kansas. There's never been a case where Dr. Mitchell has been prevented from testifying on a Daubert or a Fry type of motion. So essentially, he didn't see the need for it. There was no point in making such a motion.
It's kind of I think it was Al Salami as our case where there was discussion about futility.
Yeah.
And if a step that an attorney is accused or alleged to have been deficient in performance by not taking that, if taking the step would have been futile.
Yes, you're
then it's
exactly
not
right.
deficient.
Is the issue really the filing of the Daubert motion? Because the Court of Appeals, that wasn't the basis for the decision. Isn't the crux here whether or not Paul Morrison was deficient in his performance for failing to procure an expert that would address Dr. Mitchell's testimony?
That was the Court of Appeals ruling, and I argue that it was wrong because he did hire an expert.
He hired an expert, but not in the area to what Dr. Mitchell testified to at the preliminary hearing. He was on notice from the preliminary hearing. Here is what Dr. Mitchell is going to testify to. And then he gets an expert that is not going to testify to that. He's going to testify to other things. And then he says, well, the reason I didn't get an expert to testify to what Dr. Mitchell said in preliminary hearing is because my expert never told me to do that.
Dr. Mitchell is job is examining. Dr. Widgren, the expert that's been hired, is a forensic. His experience is other experts that were hired. They're actually the ones who are not qualified to speak on the subject. Dr. Mitchell pointed out. I've had injuries in the coming.
But isn't the issue the depolarization of neurons?
Yeah.
That is what Dr. Mitchell testified to at the preliminary hearing.
Yeah,
And wouldn't a lawyer to meet the threshold of performance that's required to say, okay, I need to get an expert that is going to try to knock down this depolarization of neuron?
Just lost my microphone, but talking about it enough. Here's the thing about depolarization. The Court of Appeals made a big deal about that. The council should have been on notice. It was some kind of I read that preliminary hearing. Dr. Mitchell said depolarization one time. It was not a central part of his overall testimony was that this was a injury that caused sudden death. I don't know that word would have jumped out at anybody.
Well, not that word, but I mean, the whole point is he's trying to explain why there can be a head injury that kills a baby without any swelling in the brain or any other kind of surrounding circumstances, and that it was electronic, it was electric.
And exactly, which is why they hired Dr. Wigren and they sent all the material to him and said, Dr. Wigren, please tell us what this is. Because as Veronica Durst said in her testimony, she says, it wasn't intuitive to me. And so what the standard that the Court of Appeals made and what you're getting at is a standard that would be impossible for almost any attorney to meet. You're asking the attorneys to be smarter and more knowledgeable on a subject than their experts. How would they know? How would they know to look into that if the expert doesn't tell them? They
Didn't
knew
their
they need.
expert, but their expert said they never asked for my opinion on that theory.
And that's where the Court of Appeals resolved conflicting evidence because the evidence conflicted on that. Paul Morrison said he talked to him about that every time. And he said that, and there's, I got case or citations to the record where he said that he talked to him about it every time. He always said, he said he talked about almost every time I talked to him. Record, volume 8, 167, 169, 244, volume 5, 232, and Durst confirmed that in her testimony in 129. So
What
for
did
the Court of
Wigren-
Appeals to come to that conclusion, they necessarily had to resolve conflicting information, conflicting evidence, because what Wigren said is he just said he couldn't remember. If you read his testimony, there's a whole lot I don't recall in there.
Did the
So-
district court make a credibility finding on that?
Well, implicitly, the district court had to make its ruling. And we have to defer to the district court's ruling in that case. I've already read to
There's no
you.
express finding of fact for, as far as reweigh, because that's what you brought up on appeal is that the Court of Appeals reweighed the facts, but the district court made no finding on credibility issues, correct?
Well, there's no way that you could get these two different opinions from the district court and the Court of Appeals if the Court of Appeals did not resolve conflicting evidence in a way that supports its opinion. There's just no way. And the Court of Appeals should not have done that. It should have deferred to the district court's decision. Even if the district court didn't explicitly say, I find Mr. Morrison more credible than Mr. Wigren or whatever, that's implicit in the court's finding.
But even if you say that's true, that Paul Morrison and Veronica Durst did bring that up over and over, they never got a response from their expert about it, right?
Actually, no, they did. They actually testified. This is again where the Court of Appeals got it wrong. He testified, unequivocally. They discussed Mitchell's preliminary hearing testimony, and what he said is every time he brought it up, Dr. Wigren said, "Why are you worrying about that? This is an old injury. This is an old injury. That's all we need to focus on." And Morrison testified. He said there was absolutely zero mystery with Dr. Wigren about the testimony that Mitchell was going to give to the jury about the cause of death and its immediacy. So in
Well,
Morrison's
that's
mind,
different than-
in Morrison's mind, he had spoken to him, asked him about it. Wigren said, "Don't worry about it. It's not an issue. This was an old injury." And that was their strategy. So you're asking Morrison to somehow be smarter than Dr. Wigren, to have some kind of extra clairvoyant capability to see through these things. And, when he's relying, the expert tells him, "Don't worry about that. This is all about the age of the injury. I got this." Why would Mr. Morrison think that he needed to go beyond? There's no
Counsel.
red flag raised.
Counsel, can I ask some, what I think are really practical questions, but going to the same issue? Did the jury ever hear Dr. Wigren say, "Mitchell's full of it. He's wrong. He doesn't know what he's talking about"? And obviously I'm paraphrasing with really
Yeah.
common sense type language. Did the jury ever hear that?
Well, I mean, Dr. Wigren testified that the injury that Dr. Mitchell said was immediate or caused.
I know he
immediate
gave
death.
an alternative explanation,
I-
and you've made a passionate argument that Wigren was there telling Morrison, "Mitchell's wrong, Mitchell's wrong, Mitchell's wrong." That I'm asking, did the jury ever hear Wigren say, "Mitchell doesn't know what he's talking about"?
Not in that type of
And
language.
so if
He-
you're a lawyer in this kind of a case, it doesn't seem to me to be a stretch to suggest that you have to perform adequately, to just ask your guy, just say, "Hey, you read what Mitchell testified to in the preliminary?" "Yeah, I did." You heard what he said here?" "Yeah, I heard it." "What do you think of that?"
Well, and Morrison did do that. And if you read his testimony, he said that every phone call he talked to him about.
No,
it-
I'm asking about what the jury heard.
Oh,
I
what the
don't
jury heard.
care about
Oh,
what he had talked to him about in
Well,
in the phone calls. I want to know, did he ask the question that would elicit the testimony from Wigren that Mitchell's testimony is, that his theory is wrong? It
No, he did
has
not.
no basis in any science that I know of, and it's completely made up.
He did not ask that question.
Okay, and isn't that brass tacks where we're at in this case. Isn't that what really matters?
No, I disagree
Okay,
because.
so help me,
Okay.
respond to that line of questioning.
Because they did present Dr. Wigren, who countered and contradicted Dr. Mitchell's testimony, not in the exact way that you suggested, but they did present an expert who was qualified, a forensic pathologist, who disagreed with Dr. Mitchell and said there's no way that this could have happened in the way he said it did, because it didn't happen immediately, that this was an old injury that predated the time when he was, and so they
The
did.
alternative theory, and that I agree with you as I read the record. That was the whole theory of the case.
And from looking at counsel's perspective at the time, that was a objectively reasonable strategy. Now, could there have been other strategies? Sure. With the benefit of hindsight, can we look back and say maybe there was a better strategy? Maybe, but that's not the test. At the time, was that an objectively reasonable thing for counsel to do? Was that an objectively reasonable strategy? If it was, it doesn't matter if they can trot in additional experts after the fact who say different things and so on, or they can show other attorneys who have done a better job. That's not the standard. Was it objectively reasonable? That's actually a pretty low bar. And I think counsel here met it. And I am way beyond my time. So
Let me just ask you something before you sit down, because you've appeared a lot in front of us, at least in my time on the court. I've always appreciated your zealous arguments, especially in major cases, which this is. We've presided over major cases. I did as a district court judge. I just do not recall. And if you can tell me, if you can, where there's been a coroner's determination of a cause of death that is testified to, and that's the basis for the cause of death in a homicide case, that isn't right. That is just bunk. Have you ever, I don't recall that ever happening, or at least, and what do you have to say about that? Are you, as a representative of the state, what do you
I don't recall that ever happening
stand
again.
here and say that's all right?
I'm not sure that it's bunk. I mean, that's the thing. That's why we have the arguing experts.
There's even Dr. Mitchell says there's no support for the theory.
Well, there's always no support for theory initially. Okay, he's made the theory. He's given an explanation for the cause of death. Okay, and he's a forensic pathologist. That's his prerogative to make that determination. I'm not a forensic pathologist. Now we have some other doctors saying it's not true, but that's why we have the battle of the experts. That's every court case where you have experts. And quite honestly, I mean, Morrison said he did internet research, so I did too. I mean, I Googled, depolarization, whatever. It's actually a thing. It is associated with traumatic brain injury. Now, whether it can cause death or so on, I don't know. That's what the forensic doctors can talk about. But from Morrison's point of view, if he did the same thing I did, he'd say, well, yeah, that looks like a valid theory. Now the doctors, I've seen many cases where you've had experts, one expert say one thing and the other expert comes in and says, no, he's full of crap, he's bunk. That happens, and those get resolved by the jury, by the finder of fact.
But isn't that what should have happened here?
Well, we're not a finder of fact up here.
I know, but isn't that the whole crux of the ineffective assistance of counsel claim? Is there should have been competing expert testimony on this depolarization cause of death put in front of the jury?
There was expert testimony that was presented on the cause of death and the timing of the death, because that was counsel's strategy. They're allowed to choose an objectively reasonable strategy. Their strategy was to challenge the timing of the death, not the depolarization, whatever it is. And that's objectively reasonable. There's multiple strategies
But a
in any given
strategy
case.
has to be made after thorough investigation.
And they did that. I mean, I've been up
Looked
here.
it up on the internet.
They hired a forensic pathologist.
It is not
That-
an expert on
that-
brain
Well, I mean,
electrostation.
according to, maybe then Dr. Mitchell isn't either. But I mean, the point is, Dr. Mitchell's a forensic pathologist. He's qualified to make his conclusions. Dr. Wigren is a forensic pathologist. He's qualified to counter those. I mean, what more do you want counsel to do? I mean, how high are we going to set this
Exactly what
bar?
Counsel did in the motion for new trial at the 4-day evidentiary hearing.
They found two doctors who are not qualified to challenge a forensic
that's-
pathologist. I
That's
mean,
your
and
opinion.
again, we're looking at
But
what
that's-
other attorneys could do. That's not the standard. The standard is, what did these attorneys do and was it objectively reasonable?
But that's why I
Hiring,
asked you at the
yeah.
beginning, that I don't understand. an attorney can have deficient performance for an omission. You even said that.
But they didn't omit anything. They hired a forensic pathologist. They hired a qualified expert. It just turns out he wasn't good enough to counter Dr. Mitchell. I mean, that's every case is like that. Every case involves experts. The jury believes one or the other. And it's not that those attorneys that lost were not ineffective or incompetent. They just lost the case. And losing the case doesn't make you defective or deficient or ineffective. Okay, they did what any reasonable attorney would do. They hired an expert, a qualified forensic pathologist to counter Dr. Mitchell. They consulted with him, as all testified many times in preparation for the trial. He gave his testimony that directly contradicted the state's case. I mean, it's not like they didn't miss the boat. It directly contradicted the state's case, but the trier of fact, the jury agreed with the state. So that's not, and we're not retrying the merits of the case here. We're looking at counsel's conduct. And that was objectively reasonable. I mean, from an objective standpoint, not a subjective standpoint, from an objective standpoint, what they did was what any competent attorney would do. Again, I'm way beyond my time. So
Counsel, I want to, Chief Justice hates it when I do this. But you said something that I don't think you meant to say, but I need to make sure.
That's
if I'm
probably-
understanding. You said that the issue was about the time of death, and we know the time of death.
oh, okay,
You were talking about the time of the fracture.
yes, you're right. I mean, the time of the injury. It was the timing of the injury that led to the death. That's
And the reason why that, I understand it, contradicts what the state's position is you can't, this injury either has to be fresh or it has to be old. And if it's old, the defendant's not guilty.
right. Dr. Mitchell's whole theory only worked if the injury was fresh. So Dr. Wiggins' testimony directly countered Dr. Mitchell's testimony. At this point, I will sit down and yield the floor to opposing counsel.
Thank you, Your Honor. The state's theory required that the injury happened right there and that the death occurred as a result of the injury that happened right there. That's this depolarization theory. Most lawyers who've done much of anything having to do with medical issues know that blows to the head cause injuries to the brain, and injuries to the brain kill people because of herniation syndrome. And that's the whole injury to the brain thing.
Okay, counsel, you've already passed my knowledge of brain injuries. But I think at its basic, I can understand the premise that I'll accept for now, that this is a brain injury. So a reasonable attorney might think, I need a brain doctor, which would be potentially a neurologist, correct?
Yes, Your Honor, precisely. And
But don't you agree that Mr. Morrison told his expert, Mr. Wigren, please look at this and get a neurologist if we need one? Did he do that?
Your Honor, there is a dispute in the evidence between Dr. Wigren and Mr. Morrison about their communications and what Mr. Morrison told Dr. Wigren and what Dr. Wigren said to Mr. Morrison.
But the district court found that Mr. Morrison was reasonable.
No, that's not true.
Well, okay, the
That's
district court
really-
found that he did not commit
Your Honor,
ineffective.
actually, the dispute, I'm wandering away from my microphone. The blame game between the two, between the doctor and the lawyer, was not resolved by either court.
Okay, well,
the
I want to get past the blame game.
Right, and that's what I'm trying to do.
If Mr. Morrison did in fact tell his expert witness, get a neurologist if we need one, is that enough to satisfy the effort required of an attorney to seek a neurologist if that's what is required?
Your Honor, that I don't think that hypothetical is enough. I mean, hypothetically, it is not enough. And the Court of Appeals specifically found it wasn't enough. If Mr. Morrison knows enough to ask the question, he has to get an answer to the question. If he's going to say he's going to rely upon the expert witness, he needs to get an opinion from the expert witness before he goes to trial. Now, in this particular case, Mr. Morrison said he told Dr. Wigren about this, but Dr. Wigren kept deflecting and never answering the question. Dr. Wigren says, I never answered the question because it was never asked of me. Mr. Morrison says that on the night before Dr. Wigren testified, in meeting with Dr. Wigren for the first time, Dr. Wigren told him that this depolarization theory was nonsense. The direct quote was, Dr. Mitchell must have come up with that from somewhere between his belly button and his taint, according to Mr. Morrison. Yet the next day when Dr. Wigren testified, Mr. Morrison didn't ask him about that, didn't say, well, tell us about this depolarization. But on cross-examination, the state did. And the state did ask whether a person could die from a blow to the head immediately. And Dr. Wigren testified, this is in the Court of Appeals opinion, Dr. Wigren testified, yes, but, and then tried to explain and was cut off by the prosecutor, and the court instructed Dr. Wigren that he would have the chance to give his explanation on redirect. They adjourned for the night, and yet the next morning when Mr. Morrison did the redirect, he didn't ask Dr. Wigren for his explanation. Dr. Wigren testified that his explanation would have been, had he been allowed to give it, that yes, you can immediately die from a blow to the head. If it's a crushing head injury, your brain is crushed. And he didn't get to tell that to the jury. Now, the problem with Mr. Morrison's position is that Mr. Morrison himself lamented his failure to develop this testimony, to file a Daubert motion. He testified he'd never filed a Daubert motion. I suggest, Your Honors, that Daubert at that time was 4 years old. We've had Daubert in the state since 2014. That was 2018. Mr. Morrison in his career had never filed a Daubert motion. But the district court never resolved this dispute between Morrison and Wigren because Judge Buchhorn decided it doesn't really make any difference whether Wigren advised Morrison of this, that it's nonsense, and it is nonsense, because even if you filed the motion, I would have denied it because I'm finding, after having conducted a Daubert hearing, because that's what Judge Buchhorn did, to deny our motion for new trial, which we filed before sentencing. We filed before the judgment was final. She decided that, that it would have been futile because she decided that depolarization is admissible under KSA 6456B, which, Your Honor, we just think she's wrong on. I mean, and apparently so did the Court of Appeals, which gets us to
But it can't be ineffective assistance of counsel to file a motion that's going to get denied.
Well, that's what was her reasoning, Your Honor.
Well, and I think we've agreed with her, and that was the fight in the two different versions of the Calamini case. But here's my question. You started out by saying that there were 2 points to make. One was the date of the injury, and then cause of death from the injury, the polarization. But it seems to me that if you're faulting the defense essentially for not having an alternative theory, like, in other words, you're telling the jury, all right, this could have been a fresh injury, but still Dr. Mitchell's nuts about how that fresh injury would have caused the death. That's really what you're saying, right? Having an alternative theory. If you disagree with Wigren, if the jury disagrees with Wigren, and accepts Dr. Mitchell's testimony that it's a fresh injury, right?
Your
That
Honor,
has to-
I
that-
you,
I may have
you-
confused it, but
you have,
the cause of, if we know polarization isn't an issue, if it's an old injury, right?
we know that depolarization can never be an issue.
If it's an old injury, it's not a thing.
If it's an old injury, she can't have done it.
Right,
Right.
right. But I'm saying to talk about depolarization, it seems to me the defense has to concede the fresh injury.
No, Your
The
Honor.
jury might, if, in other words, an alternative argument, if you don't agree with Wigrin and you believe Mitchell that it's a fresh injury, it still doesn't lead you to the death of this child.
Your Honor, the age of the injury is only significant because in order for Dr. Mitchell's theory to point to Mrs. Buchhorn, it has to be new. By his depolarization analysis, you get hit hard enough in the head, your brain will stop working, even though there's no injury to your brain. That's what he said. And there's no science that supports it. I forget which, it might have been Justice Wilson who
But it
talked
still has
about
to follow-
pediatric neurologists.
But counsel, it still has to follow the fresh injury. So if you're trying to, if as the defense, you're trying to focus on polarization or depolarization, it seems to me you're telling the jury it's possible that the defendant inflicted the injury. Now we're just arguing over whether that injury caused the death.
Not at all, Your Honor. Not at all. We're saying that there's no way a blow to the head causes head trauma can cause death without evidence of injury to the brain. There was no evidence of injury to the brain. The cause of death testified to by Dr. Mitchell is simply not science. It's junk science. And we brought in 2 world-class pediatric neurologists who testified to that. We asked Dr. Mitchell for his authority, his literature authority, and there is none. So what does 456B require? It requires credentials, number one. But then beyond credentials, you've got to show facts or data, and then you've got to have a methodology that you apply to the data, and then you have to show that you reliably applied the methodology to the data.
But if I'm a juror, I'm sitting here trying to figure out how a perfectly healthy young child shows up at daycare. The end of the day is dead. That's what I'm trying to figure out. And I know that if the defense expert is believed, it's an old injury and the defendant couldn't do it. But if it's a new injury, and I believe that, the defendant's on the hot seat.
Only if there's some reliable methodology that connects up anything she could have done to the death of the child.
There has to be, everybody agrees there's a fracture, right? It's a question of when it happened.
No, Your Honor, there was a hairline fracture, a non-displaced fracture at the base of the child's skull. Many of us have those. Many children have those. The testimony of all of the experts, including Dr. Mitchell, was that fracture didn't cause the death. What he said was that the blow to the head that caused the fracture induced energy into the brain that caused the instant death. That's just made up. That's like saying Gibble-me-gob caused death.
But for him to be right, that energy had to be transferred at the daycare center.
For him to be right, but there has to be a theory that recognizes that can cause death. I mean, it's Mrs. Buchhorn was convicted of murdering this child simply because she was there when the child died. As Dr. Suda Kessler, who is the chief of pediatric neurology at Children's Hospital in Philadelphia, one of the 2 or 3 top pediatric institutions in the world, testified. She said she sees a dozen or so kids every year that die that she can't give an explanation for their death.
But let's go back to the viewpoint of the attorney.
Yes, Your Honor.
And a reasonably competent attorney at that time understood there is a brain fracture that a pathologist would seemingly to be competent to say we have a fracture and it's a fresh fracture.
That caused the child's death. And the child is obviously passed. How would a reasonable attorney know at that time, well, that can't possibly be true?
Your Honor, Mr. Morrison made it clear in his own testimony. He understood the significance of this depolarization thing. The fact that he kept badgering Dr. Wigren about it is evidence of that. The night before he put Wigren on the witness stand, Wigren told him it was nonsense. He knew this. It was his obligation to develop that, develop the answer to that, to find out. If I've tried over 100 jury trials in my career, many of them involving complicated expert testimony. And in every instance, I know not only do I have to put my own witness on the witness stand, I've got to cross-examine somebody else's witness. How do I cross-examine somebody else's witness without any bullets in my gun? The bullets in my gun are the medical literature and the treatises that deal with that issue. The very first thing any lawyer does in preparing an expert witness or into dealing with a 456B issue, and this is as Alice Craig said, the very first thing a competent lawyer does is to investigate with his own expert what those materials are. Indeed, in this case, I would suggest that the state had no basis to even ask the question of Dr. Mitchell, because 456B requires that Dr. Mitchell have had a methodology and a way of explaining how he applied the methodology to the facts of the case to reach his conclusion. He's got to know what that literature is so that he can cross-examine the other guy who comes in to testify. Our own ethical rules require that I can't stand up in front of a court or a jury and say something that I don't have a reasonable basis for believing is supported by the evidence. We have Mrs. Buchhorn convicted of murdering a baby based upon gobbledygook, because that's what depolarization is. It's gobbledygook.
Can I ask you a question that's
Yes, sure.
right along those lines, but I want to turn you to your condition, to your cross petition and ask.
I'm glad you are, because I've run out of time.
Yeah, if you could talk a little bit about that. And my specific question, which maybe you can answer as you talk about your cross petition, is whether or not you have case law to support your argument, as at least I understand it, that the issue, the Daubert issue, is properly preserved because of the post-verdict motions.
Yes, Your Honor. I wish I could have something to give you that would directly say that. The Daubert issue was raised in two ways before the final judgment of conviction. And Judge Buchhorn denied the motion for new trial. We got in there a week or two after the verdict, and so we were in a hurry. We got this stuff going, and she conducted 4 days of Daubert hearing in which 2 pediatric neurologists. I mean, and Your Honor, I recommend you to look at their credentials.
And let me just jump in real quick and say, I don't. You can talk about the content and the merits of the hearing that happened if you want to, but what I'm specifically focused on is preservation. Regardless of what happened in the hearing, the merits.
Yes,
because the question you want to raise is, was the district court wrong?
And
but you were prevented from even reaching the merits because the Court of Appeals said it wasn't preserved.
And let me, I am often critical of myself as an appellate lawyer because I'm too much of a trial lawyer and I don't speak appellate as well as I sometimes should. But the issue was raised to the trial court when we challenged the admissibility of the evidence to her and the sufficiency of the evidence as a basis for the new trial motion, as well as a basis that she couldn't rely upon that evidence to sentence, to impose a punishment. And she had 4 days of hearing, heard all this stuff, and everybody knew it was a Daubert hearing that she was doing. And then on the basis of her Daubert ruling, she denied the motion for new trial.
How do you get around the the rule that a contemporaneous objection is required?
Because, Your Honor, the contemporaneous objection rule is intended to prevent people from raising things for the first time on appeal where the district court has not been provided the opportunity to correct the error. In this case, the district court had the opportunity to correct the error. In fact, Your Honor, there's
So we can make what amounts to an equitable exception to the contemporaneous objection?
I think
rule?
there are exceptions. There are defined exceptions, and the people who are smarter than I am who wrote the briefs put them in our brief. But the whole idea of the rule is, you know, you don't want to ambush the trial judge on appeal, and at the same time, you want to provide the appellate court with a fulsome record upon which to make a ruling. It's all here there, and the state has not said anything that it has anything else it can add to that. And I want to add in, since you said the word equity, Mrs. Buchhorn has been at the point of the gun now for 5 years, and she spent 3 years in prison before being released after her conviction was reversed. We're going to go send it back to the district court to do what? I mean, if this court decides or can decide and does decide that depolarization on the facts of this case is nonsense, that it's not anything, that it's not admissible under 456B, and if 456B means anything, it means that, then why not go ahead and do that now? Why subject her to, why should we go back to the district court that's already, we think, wrongly ruled? Maybe she would change her mind. I've never had much success in going back to judges and getting them to change their minds, but I mean, maybe she would. The state insists that they're going to go back and try and do it again on depolarization. So that's, Your Honor, I argue these things probably too much as a trial lawyer and not enough as an appellate lawyer, and it just makes no sense to go back and do this all again, slog through it again. If I might say one other word, the district court did not decide this issue between Wigren and Morrison because she didn't think she needed to. She also didn't decide all these other trial issues like cross-examining with literature, you know, putting on an expert to talk about this stuff. The Court of Appeals didn't decide the issue either. The Court of Appeals said, even if we accept Morrison's testimony, even if we believe Morrison's testimony, he's wrong because the trial lawyer who doesn't ask the expert is wrong. That would be believing Wigren. But the trial lawyer who asks the witness the question and then goes to trial without getting an answer to the question is equally wrong. And being an old guy now who's tried over 100 cases, I'm going to tell you, any trial lawyer who would ask his expert witness that critical question and go to trial without getting an answer, Alice Craig wasn't wrong about that. Thank you.
Is the court. I wrote down some notes. I hope I get to all of them. Several points I want to touch on. There was a question about a neurologist, and it's in the record that Dr. Wigren did consult a pediatric neurologist. So again, following the proper investigation, that you can't fault counsel for that because the neurologist was consulted. I want to touch on the thing about when the state asked the question of Wigren about whether or not a head injury could cause immediate death, and he said yes, but with an explanation why Mr. Morrison didn't go into that. Well, because Mr. Morrison, as he said, he wasn't sure exactly what Wigren's answer would be, and didn't know if it would help or hurt the case. So he adopted the cautious approach of not going down a path that he didn't know about. And when you look at the actual answer that Wigren gave in the post-conviction hearing, it makes perfect sense. Probably was a good thing he didn't ask the question because, and this is from page 48 of that post-trial motion, Wigren's testimony. He said, "But my answer, the explanation would be, obviously, this is a very general question, and there obviously are physical things that can happen to the head, which are physical violence that can change the electroconductivity and could stop breathing, but they're not a skull fracture. I mean, he references electroconductivity. That almost seems to, suggest that maybe Mitchell knows what he's talking about depolarization and neurons and so on. And his explanation really was just, well, that's kind of a generalized question. So, I mean, yeah, there are some things that could cause immediate death, but this isn't one of them. So I don't think that's like the smoking gun that my opposing counsel tries to make it out to be. And also, as I was listening to opposing counsel make the argument what the defense expert should have said, I'm thinking to myself, well, that is what Dr. Wigren said. I mean, Dr. Wigren argued exactly what Mr. Skepnik said. He testified in summary that there's no way a person could die from a head injury without a visible injury to the brain. I mean, that's what this case was about, whether you call it depolarization or any other label you put on it. The two experts disagreed. One said it could happen immediately with no injury to the brain, with no visible injury to the brain. He said he'd seen that a couple of times in his past practice. The other forensic pathologist said, no, that couldn't happen. You would always see injury to the brain, and this is an old injury. So again, the defense expert that was hired did exactly what Mr. Skepnik said he should have done. So counsel can't be faulted for anything they did in hiring the expert.
Counsel, before your time runs out, can I ask you to address the preservation question I was asking your opposing counsel about?
Yeah, real simply, I agree with the Court of Appeals.
But why?
The
Why
Court
are
of
they
Appeals,
right?
We actually have case law here. What I would just cite, and I'm sure you're aware of the State v. Cook, 286 Can 1098 at 1109 said clearly a post-trial motion cannot substitute for the contemporaneous.
Yeah, it's
objection
not a
requirement.
contemporaneous objection. So my follow-up question is, does that mean that this kind of a ruling from a district court is effectively unreviewable?
It's unreviewable the same way that any kind of decision by the district court in a trial that's not objected to.
No, but
is unreviewable.
I'm not asking about what the district court did during trial. I'm saying the district court could have said, you didn't make a contemporaneous objection, so I'm not going to do this. But when the district court actually goes ahead and says, well, okay, I'm going to entertain your objections post verdict, but pre-judgment, that's the narrow window that we're in, which strikes me as something not necessarily contemplated by the preservation statutes and rules. And the result of the Court of Appeals opinion is that it makes what the district court did here unreviewable. And that's what my concern is. And I just wanted to hear the state's perspective on that.
I think that's basically kind of what State v. Cook said, though, because you had a post-conviction motion there. And I think the court.
Well, is that what two-part question? One, is that result dictated by any statute or law? And two, is that a good result?
Well, now I'm going to have to go back and look at Cook. I mean, I got the note in my notes, but I'm not sure. I mean, it is based on statute. The contemporaneous objection rule is in statute. So I would say at least it's based on that. I mean, that is the case law. And yeah, from my point of view, the reason we have, I made this argument before in other cases about where we try to get past the preservation rules. We have preservation rules for a reason.
But the contemporaneous objection rule doesn't directly address this situation. It doesn't address a post-trial motion that was actually based on admissibility of evidence that was actually ruled on by the district court. Why couldn't the Court of Appeals have said, well, look, we can't reverse this conviction based on the admission of this evidence, but we can review the district court's ruling on the post-trial motions?
Well, I mean, I guess I'm going to have to fall back on Cook. I mean, the Court of Appeals obviously was bound by Cook, so they couldn't. But obviously, this court could take another look at Cook and change your mind.
And well, really, what I'm asking is does the state have a position on whether or not the statutes foreclose that?
Well, I'm going to say yes. Okay. But without, I would have to file supplemental briefing to really dig into that. But obviously, the court knows well my position on these preservation issues. As an appellate attorney, I like the preservation issues. I think we all need to have rules to abide by, and we follow them.
Quick summary: your view is that the statute makes this kind of a ruling by a district court unreviewable.
Yes, and then if I realize I'm out of time, if I can just. If the court will allow me to hit my last point on the Dauber issue.
That's fine, yes.
Okay, the Daubert issue, KSA 6456, it says that, and the case law says that an expert can testify from their experience, which Dr. Mitchell did. And, he followed, he has extensive experience. He followed accepted methods of forensic pathology and so on. That's all that's necessary to get the admission in. The case law says that rejection of expert testimony is the exception rather than the rule. The vigorous cross-examination, presentation of contrary evidence, and so on are the traditional and appropriate means of attacking a shaky but admissible evidence. And I would just close with, an expert can testify in their own experience, and it doesn't have to have a whole lot of background in literature at some point, because all theories start somewhere. Galileo had a theory that everybody thought was nonsense at one point in time. So maybe Dr. Mitchell knows what he's talking about. And I will close at this point and ask the court to reverse the Court of Appeals and reinstate the conviction. Thank you.
Thank you to both counsel for your arguments in this matter. The court will take the case under advisement. Shima, would you please call the third case on the morning docket?
Thank you, Your Honor. May it please the court. The third case on the docket for Wednesday, March 30th, 2022 is appeal number 124619 in the matter of R. Jacob Johnson, original action and attorney discipline, no briefs filed. Your Honor, that concludes the docket for the week of March 28th.
Counsel, would you please approach the lectern and enter your appearances?
Good morning, Madam Chief Justice. May it please the court. Julia Hart, Deputy Disciplinary Administrator, appears on behalf of the Office of the Disciplinary Administrator. I request permission to reserve 3 minutes for argument or for rebuttal argument.
3 minutes is granted.
Thank you. I am present and ready for argument.
May it please the court, the respondent appears in person by John Ambrosio. We are certainly ready to proceed.
Settled, you may begin your argument.
Thank you. May it please the court. This is an attorney discipline case where the parties jointly submitted a summary submission agreement pursuant to Supreme Court Rule 223. Pursuant to this rule, the parties are in agreement that the respondent violated the Kansas Rule of Professional Conduct 8.4b. The parties agree through this submission to the findings of fact and the conclusions of law, and the parties recommend that the respondent be publicly censured as a result of this violation of the rules. The respondent is licensed to practice law in Colorado, Kansas, and Missouri. In Kansas and Missouri, the respondent's licensure status is inactive. In Colorado, he has an active law license. This is a reciprocal discipline case pursuant to Kansas Supreme Court Rule 221. The events that led up to this summary submission were in November of 2019. The respondent was convicted of misdemeanor assault in Colorado. He reported this conviction to all states that he is licensed. The respondent has had no prior discipline on his license in any of the states of which he holds a law license. In Colorado, where he has an active license, the respondent entered into a joint stipulation with the Colorado Office of Attorney Regulation. In this joint stipulation, the parties recommended and the Supreme Court imposed the following discipline in June of 2020. The court in Colorado imposed a 1-year suspension with all but 5 months of that stayed, so long as the respondent completes a 24-month probation with various terms and conditions. This probation is set to expire in January of 2023, and he remains on it. The terms and conditions of this probation are set forth in the record on page 49 of volume 1. The respondent is in compliance with all terms of his probation through the Colorado Attorney Regulation Office. Following along with the reciprocal discipline in April of 2021, the Missouri Supreme Court issued a written admonition to the respondent based on this Colorado conviction and subsequent discipline. Both Colorado and Missouri found that the respondent was in violation of the rule of professional conduct of 8.4b. This is the same rule of which the Board of Discipline agreed and found the respondent was in violation of here in Kansas. All 3 states based their rules of professional conduct off of the model rules of professional conduct, and 8.4b is identical in all 3 states of which he was found in violation. Because the respondent has successfully completed the terms and conditions of his misdemeanor probation and has complied with all terms and conditions of his Colorado attorney regulation suspension and subsequent probation, I join in with Mr. Ambrosio and the respondent in asking the court to impose a public censure or a published censure in this case. Thank you.
I have one question, and this may be fairly obvious. This is part of, I think, all of our adjustments to the new process and the formatting of the submission. And you have in that submission placed one category that says applicable aggravating and mitigating circumstances, and then listed them without differentiating which you consider aggravating and which you consider mitigating. And as I said, this seems fairly obvious. It seems to me like the first 2 regarding that in essence, there may not be any aggravating circumstance. The one I wasn't sure how it was categorized was the first one, which was an attorney since 2007. It seems that everything else is likely to be intended to be a mitigating circumstance, but I'm not sure where that one fell, on which side of the line.
I appreciate that. And you are talking on page 52 of volume 1 of the record. Paragraph 26, respondent has been licensed as an attorney since 2007. I would consider that to be an aggravating factor more so than a mitigating factor, in so much that he has experience, he understands the rules of professional conduct, and this violation still occurred. As the court is aware, this is a new rule and we continue to have discussions and evolve, and I believe it will be our practice in the future that they will be separated out more clearly.
And then am I correct that everything that follows from there, paragraphs 27 through 32, were really intended to be mitigating circumstances?
Yes, ma'am. Thank you very much.
Mr. Ambrosio?
Madam Chief Justice, Your Honors, may it please the court. I love the new rule 223, and it's probably because I'm a slacker, and the less work I have to do, the better I like it. And my colleague is absolutely right. I agree with everything that she indicated during the course of her argument. She's right on target, and I agree that from now on, and I should have noticed that, it wasn't her fault. I should have divided the aggravating and mitigating pieces up so it's easier for you to review. My client does not in any way excuse his behavior on that bad night a number of years ago. He stands up to the plate and admits he was wrong. And I think we described in our submission what was going on with him. And I'm not making an excuse. Any type of violence, especially domestic violence, has no basis in any civil society. But during the time he was going through this, and again, it's not an excuse, he had a new baby that was in the house, that was in and out of the hospital on a constant basis. I think he told me he had just held his child 3 or 4 times before this bad day that this all happened. And then there's pressure. He and his wife aren't sleeping. I'm sure they're at each other, as all couples are, especially after you have a child. I'm sure it was difficult. And then you add alcohol to that stress, and we have what happened. He was inappropriate. He put his hands on the person he loves, and there's no excuse for that. He was wrong. Maybe they could have worked it out back then. She chose to call the cops, and I don't in any way falter for that. I think any woman who doesn't call the cops, or any spouse who doesn't call the cops when they're abused, makes a mistake. This couple has put this marriage back together again. The child is in good shape. The child is healthy. They're doing great. They're building a house, have built a house just outside of Wichita. He's back practicing law with the same firm in Colorado that he was practicing at the time. Everything is going great for him. I urge you to follow the recommendations of my friend and colleague in the Discipline Administrator's Office and myself, and do a censure and make it published, because that's our agreement, and a deal's a deal. Nothing less, nothing more. He's learned his lesson. You won't see this again. He's been back practicing law since a year ago. I believe his suspension, not a suspension, but his probation will be up in another 5 or 6 months, will expire 1/1/23, I believe. He's doing a good job. He's bright. He's inquisitive. He's back with the same law firm. Give him a chance to continue to practice. That's all I have to say. With your permission, he would like to address the members of the court.
Counsel, I did have one question, and whether you or your client respondent wants to address it. It sounded like as part of the terms of probation, there was educational coursework or some classwork that he undertook, and I'd just like to learn more about that in terms of whether it was anger management or.
I think with the court's permission, he'll answer that.
Thank you.
Answer that. And by the way, I also filed the affidavit because the new rule indicates you have to file an affidavit. I wasn't sure in this case if it should be filed, but I thought as an exercise of being rational and reasonable, I filed it anyway. So I apologize for that. May he address you?
Senators, thank you for giving me the opportunity to address you. I haven't practiced law in Kansas since 2010, but I
Sir,
know.
can I interrupt you? Because I'm not sure the mic's picking you up.
I'm sorry.
They always can hear me.
Sure. So be that as it may, I know that I have a continuing obligation to adhere to the ethical standards and maintain the integrity of the law. And I clearly failed by my actions back in 2019. And so for that, I truly apologize. Your Honor, to answer your question, so I did have a deferred judgment in Colorado, which required me to go through essentially a set program that they have for domestic violence, family violence. I think it was 45 weeks of not necessarily anger management, but couples management. It helps you understand some of the characteristics of your relationships, your communications, and how to be better, and how to not, I want to say, not be threatening to your spouse. You know, just little things that you may not realize. Like, for example, if you're in an argument with your spouse, pay attention. Don't stand between them and the door, for example. Like, let them know that they're free to leave. So just kind of things like that help you with your communication with your spouse. And so for me, I think it's not a set program. It's can be up to something like 48 weeks. I think for me, it was 44, something like that. But I did complete that program. Is that a sufficient answer?
Yes,
Okay.
thank you.
So with that said, my wife and I, as Mr. Ambrosio said, we're in a much better space today than we were 2.5 years ago. It was a tremendously stressful part of our life. And I do not say that to condone my actions. Obviously, I was in the wrong, but my son was in and out of the hospital the whole week leading up to this happening. And on the night in question, I had exhausted my abilities to handle appropriately my emotions. And my wife and I got in an argument, and I put my hands on her, and I never should have done that. You know, I've gone through a lot, both as a couple. I certainly have gone through a lot individually to address some of those characteristics of our relationship that were not good. And we've come a long way, and we're much stronger today as a couple, as spouses, and as parents than we were 2.5 years ago.
Thank you. Ms. Hart, you reserve 3 minutes.
Thank you, Chief Justice. I don't believe that there is anything that I need to rebut with that argument. Thank you.
Thank you. Thank you to both of you for your arguments today, or all 3 of you for your comments today. The court will take this matter under advisement, and court is now adjourned.